working on. I'm hoping that maybe if this goes well, and David and might think that maybe a colloquium, I might like to do a colloquium on the concept of analytical legal naturalism, the theory itself. Today, I'm just going to hint at it. I won't be talking about its justification. So that would just take too much time for a meeting like this. All right, let's start with the presentation. Okay, so the introduction, this is about my book. So in legal jurisprudence, the phenomena of hard cases presents itself as a dilemma between logical positivists and natural law realists. Of the former, without the metaphysical underpinning of an objective legal or moral standard, the legal positivist cannot supply convincing arguments to supplant the sovereign as the origin and authority of law. The natural law realist faces the problem of justifying the natural law. In my text, I try to develop a middle position I call analytical legal naturalism. Thus, against the legal positivist, it supplies an objective legal standard by removing, at least for the hard cases, the necessity of the will of the sovereign authority. Against the natural law realist, analytical ALN provides a non-moral standard that avoids the need for meta-ethical speculation. Finally, ALN provides a standard that not only supplies the universalizable punch to avoid political subjectivism, but it does so in a conventional manner. Thus, ALN does not require a moral or modal reality as truth-making characteristics. Rather, it makes what is legally valuable or disvaluable dependent upon empirically verifiable facts that are legally relevant. All right, so in this presentation, there's 3 items. I'm going to talk about hard cases, Ronald Dworkin's view of hard cases, and finally talk briefly about 2 hard cases settled by the Supreme Court that consider the anti-sodomy laws in Georgia and Texas, respectively. All right, so the question then is, what is a hard case? Hard cases emerge when a judge, and in particular the Supreme Court, is faced with a legal issue without having little or no case law or the Constitution to make a decision about a case. This problem leads to the view that the judges will and must go beyond the text of the Constitution to something. For example, to something like the Judeo-Christian scriptures, moral theories, action-centered theories, moral intuitionism, innate ideas, positivism, natural law roots, ancient roots, and so forth. I also argue that there are legal cases which may be related in some way to case law, but one aspect of the case is ambiguous. In such a case, what is typically needed is analogous to a software patch, namely a set of changes to a computer program, designed to fix it or improve it. In my research, I've noticed different kinds of legal patches. One example of a legal patch is the notion of the undue burden applied by Justice Sandra O'Day in Casey. Another patch that I found, which was used for a while, was called physical penetration. It was a rule used in Olmstead versus the United States. Another famous patch is the notion of privacy that was created and used in Griswold versus Connecticut, and Katz versus United States, Stanley versus Georgia. It was used in Roe versus Wade, and I'm pretty sure it was used in Oberfeld. I meant to double check that. In many cases, my notion can act as a patch, and in fact, that's what I've come to see it more as. So in my text, I try to show that my legal patch works better than other patches, right? For example, one of the cases I look at is Griswold, and so I think my patch could have worked better. Now, to illustrate the cases, I have 3 here that typically are mentioned, and Ronald Dworkin talks about all three of these. So let me get to the point where this is at, and just give you kind of a brief overview of what they mean. Okay, let's see. All right. So, okay, the first one, Riggs versus Palmer. It was decided in 1889. So this case by the New York Supreme Court, this case is discussed by Dworkin because it's an example of a hard case that had no probate or criminal laws available to help the justices adjudicate the case. That said, the case is fairly simple and straightforward. The families of Riggs and Preston, daughters of Francis B. Palmer and the grandson of Francis B. Palmer, his name is Elmer E. Palmer, were listed to inherit his estate upon his death. Apparently, Elmer E. Palmer reasoned that when his grandfather married Mrs. Bressie in March 1882, he might change his mind and change his will, effectively eliminating him from his inheritance. To prevent this, Elmer poisoned his grandfather and murdered him. Riggs versus Palmer reflects the attempts of their daughters, Frances Palmer, to prevent Elmer from receiving his inheritance. Justice Earl, who wrote the court opinion for the New York Court of Appeals, penned the following: shall he acquire title by murdering him? If he had gone to the testator's house and by force compelled him, or by fraud or undue influence had induced him to will him his property, the law would not allow him to hold it. But can he give effect and operation to a will by murder and yet take the property? To answer these questions in the affirmative, it seems to me, would be a reproach to the jurisprudence of our state and an offense against public policy. As a result, Justice Earl maintains, quote, my view of the case does not inflict upon Elmer any greater or other punishment for his crime than the law specifies. It takes from him no property, but simply holds that he shall not acquire property by his crime and thus be rewarded for its commissions. Okay, that's Riggs and Palmer. That's considered a hard case at the time. Now, the other one, which I'm going to be talking about more at length, is the McLaughlin case, which was a British case that was ruled by the House of Lords. Okay, so it's a British tort case. The facts of the case are fairly straightforward. Nevertheless, it's unusual because of what the claimant desires. So around 6 p.m., this is in the early 80s, the claimant was notified by an individual who was a witness to the accident that her husband and children were involved in serious accident 2 hours early. She was taken to the hospital and discovered that one of her daughters was dead, and she witnessed the stark injuries her husband and other children suffered. The claimant sued the driver of the truck, who admitted negligence that caused the accident, because she claimed that what she witnessed caused her severe shock, which resulted in a psychiatric illness. Now, it's an unusual case because of the lack of law to adjudicate the facts. The closest case was Chadwick versus British Railways Board. The claimant, Chadwick, who'd witnessed a terrible train wreck close to his home, endeavored to rescue and offer comfort to the survivors of the train wreck. Later, Chadwick successfully sued British Railways for a severe psychiatric illness he claims that resulted from what he witnessed. The Chadwick decision, based partly on his proximity to the accident and his personal involvement in the case, brought to the forefront the McLaughlin case, the issue of whether she was sufficiently proximate to the event to recover damages. Initially, the lower court denied her appeal because her case, compared to Chadwick, where the claimant was at the accident site immediately after the accident were distinguishable, namely, the psychological harm of the mother was not foreseeable. She appealed this to the Court of Appeals, and although the Court of Appeals denied their request, they did so for different reasons. On the one hand, they did agree that the psychological stress response of McLaughlin was foreseeable. On the other hand, awarding her compensation would set a policy that would lead to untoward and absurd consequences. Finally, it went to the House of Lords, which upheld her appeal. The House of Lords did not think that the potential for untoward consequences identified by the Court of Appeals should be used to deny her the compensation for her suffering. Thus, in order to adjudicate future cases and avoid the potential abuse for similar but spurious cases, the House of Lords set in the following parameters. 1, the class of persons whose claims should be recognized. 2, the proximity. And 3, the means by the shock is caused. So the class of persons is limited to the closest family ties, specifically parent and child. The husband and wife relationship is excluded because adults should be able to endure such tragedies. Excluded are ordinary bystanders who may witness an accident. This is so because the defendants cannot be expected to compensate the world. All right, so those are two, and I'm going to talk more about that one. Examples that Dworkin brings forward as hard cases, right? There was apparently no sort of case law in place for them to make some sort of decision. All right, now, with that in mind, what I want to do is, how does Dworkin fit into this whole discussion of hard cases? Well, I'm going to go through this kind of quickly. I'll try to go through it quickly. So I spent quite a bit of time talking about, I have a chapter dedicated to Austin, Hart, and Dworkin. So it comes from this chapter 5. And so there are a number of things that we want to talk about. First of all, okay, of course, he does reject legal positivism of Austin and Hart. And then he presents his own views, which I've listed here in terms of how I take to understand the progression of his thought. So we want to talk about constructive interpretation, the 3 interpretive stages, the chain novel, and these 2 individuals, Hercules and Herbert. And then, so let's move on to that. All right, now, in terms of discussing how to solve hard cases, I use Dworkin because he's very specific about his approach to hard cases. And so he begins with what we've come to be known as constructive interpretation. So Dworkin's constructive interpretation is it's intuitive. And for Dworkin, it's the aim of all legal interpretation to constructively interpret the social practice of law by imposing purpose upon it, such as, quote, to make it of the best possible example of the form or genre to which it is taken to belong, end quote. So he immediately qualifies this point. Initially, he reasons that because constructive interpretation is part of creative interpretation, which is analogous to art interpretation, not every interpretation will work. On the contrary, like works of art, he appears to insist that we must limit our interpretation to the author's intentions, if appropriate, or at least to an obvious interpretation of the object itself. Dworkin also qualifies this view that, like a work of art, a social practice may possess data that determines the value of the artwork or the social practice. So competing interpretations may be equally valid. Later, he adds another qualification. Constructive interpretation, while similar to creative interpretation of the artistic kind, is slightly different. And so here's what he says. Apart from the endeavor to understand the artist's conscious mental states, which are in most cases unavailable, we may gather in a creative sense what the artist nevertheless may have intended. We may, as Dworkin suggests, engage in an imaginary conversation with the artist, asking him from a contrary to fact perspective what the author thinks about a new proposed interpretation. If it is an interpretation the artist is unfamiliar with, well, it is an interpretation the artist is unfamiliar with. Nevertheless, we can imagine asking the artist his opinion about the new interpretation. If this new interpretation somehow satisfies what the artist may have had in mind, that is, if it captures the feeling he could have had, and from our creative endeavor, we estimate that he now accepts this interpretation, then our understanding of the work of art will be a part of our constructive interpretation of the work of art. Constructive, then, is a part of Dworkin's third conception of law, called law as integrity. Prior to that, Dworkin discusses two other conceptions of law, that is to say, conventionalism and pragmatism personification, and rejects both views. Thus, according to Dworkin's third conception of law, propositions of law are true if they figure in and follow from the principles of justice, fairness, and procedural due process that provide the best constructive interpretation of the community's legal practice. Of course, Dworkin makes clear that the first two conceptions of law involve interpretation, but not the kind involved with constructive interpretation. This is so because conventionalism merely requires judges to base their rulings on past legal decisions that are available and conventionally recognized to have legislative power. Once case law has been established, interpretation stops. Pragmatism stipulates that judges must decide what rules will best work for the legal future of the society. Once such a view is stipulated, interpretation stops. Constructive interpretation is different. It combines both backward and forward interpretations of legal claims. Additionally, as Dworkin makes clear, interpretation continues throughout the entire process, even if the case law has been thought to be successfully interpreted. Okay, on to the three interpretive stages. This is very brief. To make clear Dworkin's view of law as integrity, it's important to start with his stages of interpretation. There's the pre-interpretive stage, the interpretive stage, and the post-interpretive stage. The first stage identifies the material to be used to interpret some sort of issue. In this context, we might imagine the famous cases of Riggs and Palmer and Henningsen versus Bloom Motors. The second stage considers some sort of justification which fits, so to speak, the facts or the elements of the case or cases at the pre-interpretive stage. The last stage attempts to adjust the justification given at the second stage and may include making clear the apparent disanalogies that may count against the second stage. Of course, the sum and substance of the whole matter is Dworkin's second stage, the interpretive one. It's at this stage that the judge works to fit a case into the judicial history of the culture in which the case occurs. Although such an attempt may involve originalism, whether the appeal is to original intent or original meaning of the authors of their own rule of recognition, Dworkin subtly qualifies this point. On the one hand, he states that law integrity does not aim to recapture the ideals of the original framers of an amendment. On the other hand, he elucidates that integrity as law aims to justify what they did, including the ideals when necessary, in order to create a story that connects the past and the future together. Thus, the decisions about a new case, especially hard cases like Riggs and Henningsen and McLaughlin, will see the interpretive proposal fit and justify the decision that law as integrity requires. Now, to illustrate this, he brings in this interesting concept called the chain novel. All right, so let's see. So he familiarizes his viewpoint with an approach that's analogous to the interpretation often taken to interpret a literary novel. The approach does not aim to discover what the author's purpose is for the novel. Rather, as Dworkin makes clear, the interpreter aims to impose a creative interpretation on the text, which interprets the text in its best possible light. Therefore, likewise, creative interpretation in law aims to treat legal documents in the same way. Creative legal interpretation then seeks to impose an interpretation on the text that represents the best possible interpretation of the text. In particular, then, the analogy Dworkin advocates is something akin to an interesting phenomenon of the chain novel. On this view, a group of authors intend to write a novel. On a standard collaborative interpretation, the novel would represent the collective results of the authors in the same way as a scientific or philosophical article might represent the collaborative efforts of an article. A chain novel, however, is slightly different. Surely, the novel is written as a collaborative effort, but each chapter of the novel is written by a different author. In such an endeavor, each author, except the first author, intends to add consistently to the plot line of the preceding authors. Thus, the presupposition, warranted or otherwise, of such a novel is that each author intends to make it the best novel possible. Before Dworkin turns this discussion to the application of legal context, he considers two qualifications. Dworkin partially wraps up the nuts and bolts of his view of the chain novel discussion by considering two dimensions which act as qualifications. The first qualification he calls the dimension of fit. The issue, as I understand it, concerns the requirement that no interpretation of the novel that can be recruited will be worthy of confidence. It must be the best fit. Nevertheless, although there may be the assumption that there must be a perfect fit, Dworkin clarifies that the contribution of the chapter must not reflect or capture perfectly the main plot, subplots, themes, and readings of character and so forth of the previous chapters. The second dimension concerns the possibility of having at least two interpretations that fit the text. Like the first dimension, such a situation presents a similar problem. How does one judge or make an assessment that one interpretation fits better than another interpretation? Although a precise answer is not forthcoming, the writer, apart from flipping a coin, eventually should be able to develop a sense of when an interpretation fits poorly and one that fits, all things being equal, as a hand might fit a glove. Nevertheless, all guarantees aside, Dworkin comments that it may turn out that the interpretation he chose and uses as his model to write his own chapter may fail. Thus, if possible, then our author must return to the text to reconsider and decide upon a new interpretation. All right, so now what I want to do is talk a little bit about these two characters that he creates, and one is called Hercules and the other one is called Herbert. And of course, he's making reference here to Hart. All right, so he talks about Hercules in two different, in taking rights seriously and later in Law's Empire. So what I'm going to try to do is perhaps just jump ahead, looking at the time, and try to talk about Hercules in Law's Empire.
Hey, Sam, can I interrupt with a quick question?
Yes.
So I don't know, would it be helpful for you to advance your outline beyond?
Oh, sure.
Thank you. Mm-hmm.
Okay. Okay, one moment. Is that better?
Yeah, that's better.
Okay. Thank you for bringing that up. All right, let's see. Okay. All right. So Dworkin spends a significant amount of time discussing Hercules in Law's Empire. Again, who is Hercules? Well, Hercules in both texts is a philosophical judge who has superhuman skill, quote, superhuman skill, learning, patience, and acumen, unquote. Hercules, with his special powers, is enlisted to handle hard cases. The first he handles, he talks about abortion. And so he's enlisted to talk about whether or not the state has an interest in preventing abortions in the first trimester. To make this point a little clearer, Dworkin's Hercules character is part of his, what I call ideal judgment theory. This is the view that moral principles are made true or false by whether they would result from the assessment of an ideal judge who is in the ideal conditions to make judgments. So appealing to an ideal judgment theory requires us to follow the meta-ethical principle that states that whatever the ideal judge claims is true or false is true or false. In this case, whatever Hercules decides is legally true or false is in fact legally true or false. So I'm jumping ahead then into talking about Hercules and Law's Empire. And I'll try to limit my comments to Hercules' relationship to political morality. So we pick up the discussion, so to speak, with Hercules attempting to adjudicate another hard case, the very famous McLaughlin case. The emphasis Dworkin places upon this discussion is not so much on what he decides about the McLaughlin, but how he decides the McLaughlin case. To decide this case, Hercules must choose between 6 available interpretations. Ultimately, Dworkin explains that Hercules, quote, must decide which interpretation shows the legal record to be the best it can be from the standpoint of substantive political morality. Hercules' decision is fully consistent with the House of Lords that the best way to solve the McLaughlin case is by granting compensation to the wife, but not compensation which would impose draconian financial burdens on those who are careless. So my question then is, why is this the best one? And here's what I take to be Dworkin's answer. Dworkin agrees with the interpretation above because Hercules' view of political morality keeps distinct the notions of justice and fairness. Dworkin in an earlier text argues that fairness and justice are independent of one another. This means that fair institutions may endorse unjust decisions and unfair institutions may produce just decisions. Of course, this is an interesting and controversial position to defend, but how does this help us to understand the problem Hercules faces now? Here's what I take the text to say, but it's terribly complicated, and I struggled on trying to interpret this correctly. First, Hercules may think that a decision to limit compensation is warranted by justice, even though he doesn't say why. At the same time, Hercules may recognize that such a view may be promptly and vigorously disposed of by the majority of the public and be unknown in the political and moral rhetoric of the times. Hercules may instead side with the state on the view that the draconian measures are unfair, which makes sense, but that the people's need for justice appears to override such a decision. Thus, as Dworkin makes clear, Hercules nevertheless prefers fairness to justice in this case. As a result, Hercules' preferences reflect a deeper account of his own moral convictions about the role that justice and fairness should play in a decent government. The reason why Hercules prefers fairness to justice and how this reflects his moral convictions, including how this relates to the role of political morality, is unclear. I imagine that the answer simply turns on how we should decide whether fairness or justice applies. In this case, to decide between two such important moral outlooks, we would need a metamoral principle of some sort to make such a decision. In this case, Hercules' political morality, namely in Hart's terminology, a secondary principle may be needed. Again, if such a basic principle is needed to decide between two primary principles, we may need to apply the natural law. The reason is that it was designed to discriminate between what rule or law deserves focus or which law or rule is just or unjust. Unless I'm mistaken, it's my view that Dworkin's political morality is a natural law account. Now, here's what I want to do is I want to talk a little bit about a paper written by Dworkin called Natural Law Revisited. And I was introduced to this paper by a scholar named Tom Brooks. He sort of hand waves it in terms of its significance. And when I got it, I couldn't believe what I was reading. So even though it looks like an offhanded, obscure remark by Dworkin in which he grudgingly identifies his views as natural law account, but that this is not the case at all. Although Dworkin seems to distance himself from natural law point of view in much the same way one may distance oneself from a bad marriage, he endorses natural law. Dworkin's article, Natural Law Revisited, is the defense of a natural law account. Even though this may be the case, it's not a typical defense of a natural law that one might expect. And of course, this is where the first part of my book, I try to describe and evaluate at least 6 different versions of natural law. Dworkin recognizes that his view has been criticized because of his alignment with the natural law account. His response to this claim appears to be ignored. Quote, suppose this is a natural law. What in the world is wrong with it? Unquote. What precedes in his article is not a defense of the metaphysical underpinnings of the theory so much as a discussion of its necessity to maintain the close connection between law and morality. Moreover, what is also misleading is that throughout Dworkin's article, he uses the term naturalism instead of the locution natural law. At first glance, the former reference does not automatically resemble what we might expect from Dworkin's article. The reason is that the term naturalism has its roots in different legal and philosophical contexts, which do not resemble a natural law discussion at all. That said, what appears to be overlooked is Dworkin's defense of natural law in 2 paragraphs on page 165 and 166. He begins his argument by making clear that the crude character of his viewpoint is more appropriately called naturalism. That said, Dworkin does not give any reason why the ambiguous term naturalism is better than natural law. With this brief qualification, I will try to spell out Dworkin's role of natural law in his viewpoint. This is not easy to do because the argument does not fall clearly into any recognizable pattern of reasoning. Nevertheless, I'll try to spell out his argument as clearly as possible. Dworkin writes, according to naturalism, judges should decide hard cases by interpreting the political structure of their community in the following perhaps special way: by trying to find the best justification they can find in principles of political morality for the structure as a whole, from the most profound constitutional rules and arrangements of the details of, for example, the private law of tort and contract. And that was a quote, by the way. So with a focus on hard cases, perhaps cases with little or no prior case law available or nothing with the Constitution to help illuminate the case, a judge may be forced to interpret the political structure of the community by finding a principle in political morality that will act as the best justification for the case at hand. But such an abstract approach does not quell our reservations for what this might entail. Fortunately, Dworkin doesn't leave us hanging. On the contrary, he directs our attention to parts of the McLaughlin case and pushes us to consider how a judge should decide, if at all, for emotional and psychological damages on behalf of the plaintiff. That is, the process begins with the judge looking for interpretation to apply to the McLaughlin case with the hope that the interpretation, that is the moral principle, which reflects the content of the natural law, will justify adjudication of the judge. Of course, what may not be noticed is the following qualification. The interpretation must be consistent with the entire body of law. This qualification raises Dworkin's need to seize on the opportunity to introduce Hercules. So how does such an ideal judge in this situation work? Initially, Dworkin stipulates the principle needed to deal with the hard case will have to be the best translation that will fit with the different principles and rules within the entire body of law. That said, as Dworkin makes clear, only the superior intellect of Hercules can determine how a principle of political morality will fit so closely within the political structure as a whole. He illustrates this ideal position by contrasting with real judges. Real judges, Dworkin explains, are not capable of making such an intellectual effort. Rather, the whole truth is not known to a real judge. He will not be able to provide a complete justification for the principle. Nevertheless, following Hercules' ideal approach, tapping into, so to speak, the doctrine of natural law, real judges will also have to adjudicate at times by making use of the natural law to solve hard cases. As Dworkin comments, quote, "It's obvious why this theory of adjudication invites the charge of natural law. It makes each judge's decision about the burden of past law depend upon his judgment about the best political justification of that law. And this is, of course, a matter of political morality." All right, so I'm going to stop there in terms of that brief account. And so basically, I go on in this text to ask, to draw some questions about, okay, so if he's going to use a natural law account, then which one should he use? So I outline in my text the natural law account from the Stoics, Aquinas, Grotius, Hobbes, Pufendorf, and Locke. So which one are we going to use? Ultimately, what I try to argue is that none of them are workable. And so I reject them all. I'll have to save that line of discussion, that argument, for another time. What I'd like to do now is, at least according to the outline, is talk about how this discussion might be relevant for the anti-sodomy laws in the states of Georgia and Texas. I think that's where we're at. All right. Okay. All right. So why are the anti-sodomy laws here in the states of Georgia and Texas, namely Bowers versus Hardwick in '86 and Lawrence versus Texas in 2003, relevant? First, they're examples of hard cases. If we assume that the aim of all legal interpretation is to constructively interpret the social practice of law by imposing purpose upon it, such as to make of the best possible example of the former genre to which it is taken, we can do this without appealing to a moral viewpoint, right? So that's my analytical legal naturalism is a non-moral account. And later, what I try to explain in the 6th chapter is why my argument for that claim. So can we look at these cases, hard cases, without appealing to the law of nature. And so what I had now here are some hot and fast quotes that will bring, I think, the issue forward. Okay, so Bowers upheld the sodomy laws in Georgia. So early in the majority opinion, the Supreme Court writes, striving to assure itself and the public that announcing rights not readily identifiable in the Constitution's text involves much more than the imposition of the judge's own choice of values on the states and the federal government. The court has sought to identify the nature of rights qualifying for heightened judicial protection. Later, the majority opinion lays out its rationale. Sodomy was a criminal offense at common law. You know what, I didn't talk about the cases. I'm sorry about the facts. I meant to talk about the, probably not familiar with these cases. So basically, in Bowers, the facts are, let me see here. Okay. A police officer arrived at Michael Hardwick's home to serve him an arrest warrant for failure to keep a court date. According to the officer, one of Hardwick's housemates answered the door. He told the officer that he did not know if Hardwick was home, but that the officer was free to enter and look for him. As the officer walked down the hallway, he passed a partially open bedroom door and observed Hardwick engaged in sodomy with another man. The officer arrested Hardwick for violating a Georgia law that prohibited the practice of oral and anal sex. The district attorney decided not to pursue the matter, but Hardwick and his ACLU attorneys challenged the law, asserting that it violated the fundamental right to privacy as articulated in Griswold and should be subject to strict constitutional scrutiny. So sorry about that. I meant to put those facts in. All right, so the majority then argues this: sodomy was a criminal offense at common law and was forbidden by the laws of the original 13 states when they ratified the Bill of Rights. In 1868, when the 14th Amendment was ratified, all but 5 of the 37 states in the Union had criminal sodomy laws. And in fact, until 1961, all 50 states outlawed sodomy. And today, 24 states and the District of Columbia continue to provide criminal penalties for sodomy performed in private and between consenting adults. Later in the same paragraph, against this background, to claim that a right to engage in such conduct is deeply rooted, deeply rooted in this nation's history and tradition, or implicit in the concept of ordered liberty is at best factitious. Now, that's the majority opinion. Chief Justice Berger concurs, and it's also, his concurrence is also picked up in Lawrence. So I want to read what Berger has to say. As the court notes, the prescriptions against sodomy have very ancient roots. Decisions of individuals relating to homosexual conduct have been subject to state intervention throughout the history of Western civilization. Condemnation of those practices is firmly rooted in Judeo-Christian moral and ethical standards. Later in the same paragraph, he says, to hold that an act of homosexual sodomy is somehow protected as a fundamental right would be to cast aside a millennium of moral teaching. Thus, the majority in Bowers rules that fundamental liberties are characterized as those that are deeply rooted in this nation's history and tradition. This is, quote, a type of liberty that, according to White, consensual homosexual sodomy was surely not, unquote. It should be noted that the privacy patch was not used, nor was any implied harm principle patch was used that might indicate that the liberty of the members of the homosexual community were being violated. My ALN, I call it a kind of harm principle, a neo-Lockean harm principle patch. The dissent led by Black men, including Brennan, Marshall, and Stephen, argued that the issue is not about the matter of the right to engage in sodomy, but instead a question of privacy rights. Now, 17 years later, I think it was, the state of Texas brought forward another sodomy issue in Lawrence. Now, here's what happened in Lawrence. It's similar to Bowers. The case begins with a police visit to a private residence. After receiving a phone call about a possible weapons disturbance, police officers in Houston, Texas, entered the apartment of John Geddes Lawrence, where they observed Lawrence and another man, Tyrone Garner, engaging in a sexual act. The two men were arrested and eventually convicted of violating a Texas law that made it a crime for two persons of the same sex to engage in sodomy. This law, unlike the one at issue in Bowers, applied only to participants of the same sex. All right, so here are the arguments that the petitioners use in favor of Lawrence and the state of Texas. Now, what the arguments are and how the ruling and how they rule are slightly different, but I think they're worth looking at. The Texas law is unjustified, okay, in favor of Lawrence. The Texas law is unjustified violation of privacy and liberty rights. All Americans, including homosexuals, have a right to privacy in the home, to bodily integrity, and to make their own choices about private consensual sexual relations. Texas cannot justify abridging these rights. The principles of stare decisis do not require adherence to Bowers' precedent because of some of the assumptions underlying the Bowers decision, such as the belief that contemporary morals and tradition condemn homosexual sodomy are no longer reliable. So a lot of the text in Lawrence is spent challenging the facts that were used in Bowers about the history of sodomy. The Texas law denies homosexuals the equal protection of the law by singling out one group, homosexual men, for disadvantaged status without any legitimate legislative purpose. The state of Texas responded this: the court should adhere to Bowers and reaffirm the 14th Amendment due process guarantee, and reaffirm that the 14th Amendment due process guarantee protects only those personal liberties that are deeply rooted in tradition, that is fundamental. The historical prohibition of a variety of types of extramarital sexual conduct indicates that the homosexual sodomy is not a fundamental right. This statute, because it's neither infringes a fundamental right nor is based on suspect classification, needs only to implicate a legitimate legislative end to survive a lesser kind of scrutiny. Two worthy government goals are served by the act: the implementation of public morality and the promotion of family values. The statute does not evince a discriminatory purpose because it's facially applicable not only to homosexuals, but to those regarding themselves as bisexual and heterosexual. All right. Apart from the reasons above, the majority in Lawrence argues that Bowers is overturned because it does not have continuing validity. This is so primarily because, quote, equality of treatment and the due process right to demand respect for conduct protected by the substantive guarantee of liberty are linked in important respects, and a decision on the latter point advances both interests. If protected conduct is made criminal and the law, which does remain unexamined for its substantive validity, its stigma might remain even if it were not enforceable as drawn for equal protected reasons. When a homosexual conduct is made criminal by the law of the state, that declaration in and of itself is an invitation to subject homosexual persons to discrimination. So that's the majority quote here, appealing to the liberty rights and not to privacy. Ultimately, from my perspective, if the reason to overturn Bowers and to annul anti-sodomy laws rests upon an implied patch, namely a harm principle patch, he could defend and justify the following lines of reasoning from Lawrence. So right at the very end, the majority has this interesting quote. The present case does not involve minors, quote, the present case does not involve minors. It does not involve persons who might be injured or coerced or who are situated in relationships where consent might not easily be refused. It does not involve public conduct or prostitution. It does not involve whether the government must give formal recognition to any relationship that homosexual person seeks to enter. The case involves two adults who, with full and mutual consent from each other, engage in sexual practices common to a homosexual lifestyle. The petitioners are entitled to respect for their private lives. The state cannot demean their existence or control their destiny by making their private sexual conduct a crime. The right to liberty under the Due Process Clause give them full right to engage in their conduct without intervention of the government. It is the promise, and they quote here, it is the promise of the Constitution that there is a realm of personal liberty which the government may not enter. Thus, if the notion of liberty, okay, end quote. Thus, if the notion of liberty in the 5th and 14th Amendments imply the government must avoid violating the personal liberty of its citizens, minimally it must avoid unjustifiably harming its citizens. All right, so at that point, that really constitutes the end of my presentation. David, if you think questions are appropriate now, then.
Yes, absolutely. Let's open it up for questions. Questions or comments from anyone? Arlo, I see your hand. Go ahead.
Yeah, I was just wondering about the chain novel. So I just want to make sure I understand the analogy. Is it that the judge's ruling or the Supreme Court ruling, is that analogous to the continuation of the first chapter of the novel or whatever? I don't even know how a chain novel works, but
yeah,
it's like the initial law is the first chapter, and then the judge's ruling is the second chapter, and there may be some creativity involved, but you're trying to keep it consistent. Is that how the analogy goes?
I think that's right. Yes. The hard cases involve then adding to that novel, right? One that's consistent with, right, with the past as far as possible. So the decision cannot be sort of, it has to be linked as closely as possible to prior to the history of not only the Constitution, it has to be linked to that, but also our own sense of public morality. So that story then would have to be written very closely. But it's an interesting analogy, though. I like what he does with that. In fact, he tries to apply it to different interpretations of A Christmas Carol, which I didn't go into.
I have one follow-up question based on that. So it seems to me like that analogy primarily is helpful for cases where the law just blatantly leaves something out, like in the hard cases that you mentioned.
Yeah.
But
Yeah.
in cases that also, in other types of difficult cases, the issue is more, it's unclear what is even written and or intended by the law. In those cases, I'm thinking the analogy wouldn't be as helpful because, you know, I guess the analogy would be you don't even know what the author in the previous chapter was even going for. So how can you make another chapter that's consistent with that if you don't even know what plot they're trying to get going?
Right, yeah, and that would be right. Yeah,
Okay.
I would agree with you. Yeah. So the chain novel is my understanding. The chain novel presupposes that there's some sort of foundation or some sort of text in place that we have to understand, and then also then add to that understanding of the text.
Okay,
So
thank you.
that's a nice reflection. Question.
Are there other questions or comments? I see one in the chat.
Okay.
I wonder if you, Sam.
Oh, David, I can read the question if that might
Oh,
help.
go right ahead, Frank.
I just want to, so I thought we were queuing up. But Sam, I just wanted to see if you could expand on maybe a couple parts of your presentation. One
Okay.
that you were bringing out earlier, you were mentioning, as Arlo just talked about, the chain novelist. Could you talk a little bit more about the distinction between the chain novelist and what you consider a patch? So I think there's something really significant there about the role of a judge. You don't necessarily have to be Hercules to come up with a patch. And second, talk maybe a little bit more about analytical legal naturalism and how that might provide a better way to answer these cases and maybe some other cases than the terminology of a right to privacy.
Okay.
I'll let you answer any part of those that you'd like to.
All right. So what's the relationship between, say, a patch and a chain novel? Is that right?
Yeah. Yeah, I think it's actually written in your chat too. I have a version of that too. So, oh, it's too complex.
So I imagine, well, that's a really great question. Let me think about that. Of course, the patch, as I see it, would be part of a story, right? That would be part of this chain novel. So although it might be a brief chapter in the sense that the patch is going to attempt to solve a problem that other case law might have a bearing upon, but there's a gap there. And so in terms of understanding then and bringing together the story, then somebody might have to come in and say, look, the story has been written, but there's a flaw. And so what we have to do is we have to repair this flaw. And here is a way of doing that. So it would be, just thinking here on my feet, given the kind of analogy that he's using here, then again, I might think that that's right, that it's a small repair in a larger story that's being written. Now, the other answer is, how does my view work? Well, analytical legal naturalism basically says something like this. I'm following Locke. It's a neo-Lockean principle that if someone's a person, then they're born free and equal. And that if anybody is born free and if anybody is a person, they'll be born free and equal, and as a result, nobody should harm one another. So I talk about the harm principle there. So how would I talk about, I've been thinking about this, how would I talk about Bowers and Lawrence? Well, what's interesting is that Lawrence does what I would have done myself. I would have began with the notion, well, here we got two individuals who are born free and equal, right? And because of that, they shouldn't harm one another. So I would look at the facts and I would ask myself, where's the harm, right? And so in this case, what's interesting is that is that because there are no harmful facts, then there's no reason why the state has any interest in preventing them from their sexual activity. So let me see if I can put this in a little clearer, right? See, the notions of equality and freedom here would be that we have no reason to subject them or no reason to prohibit them from doing this, right? The idea is that, I gather from Locke, is that if someone tries to harm somebody else, they're taking up a position. And they're taking up a position of subjugating the individual, the other individual. And this denies the fact that they are a creature that's free, a person that's free, and because if it's a person, this individual is free and equal. So my assessment then would be that the Lawrence decision right at the very end shows the kind of approach that I would take with this neo-Lockean harm principle, that since there's no harm, then we have to let them, we have no interest in them preventing, the state would have no interest in preventing their activity. I'm sorry, that's sort of long-winded. You want to follow up with a clarification?
You know, I think that's a good and helpful answer. I think some other people may have some questions as well, so I'll defer to them. I could ask lots of questions going forward.
Yeah, I know.
But I'm going to ask, but I will. I'll just leave it there for now.
Okay.
Give other people a shot.
I do that every time. I always talk when I'm muted. Not seeing anybody else jump in, I'll ask a question.
Yeah.
So Sam, I want to make sure, first of all, that I understood. I think it was the first case you talked about, the Riggs case.
Yeah.
So was the problem, was the reason that was a hard case, was it that there was no explicit law saying that if you murdered someone so that you would benefit by inheritance, there wasn't specifically a law saying you wouldn't get the inheritance in that case? Is that?
I think that's right. Yeah.
And so if I understood the judge's reasoning that you explained, I would call that an a fortiori argument, an argument from the stronger. So in other words, if you can't steal the money from someone, you can't assault someone and get the money, then even if there's not an explicit law that says you can't get the money by murdering them, logically it would follow it's the same principle. Am I on the right track here? So,
I think so too. Yeah.
See, it seems to me that kind of reasoning could be used in lots of other cases where something isn't explicitly laid out. And let me just offer you one example and see what you think of it.
Yeah.
I saw Scalia interviewed on 60 Minutes years ago, and he was asked a question about whether the torturing of detainees at Guantanamo Bay was constitutional in light of the 8th Amendment prohibition against cruel punishment.
Yeah, right.
And Scalia's answer, he was very glib about it. He said, "Oh, it's clearly constitutional. You know, no constitutional problem at all." And so then the question was, well, how do you figure that? And his answer was, it's not punishment. You know, the 8th Amendment says no cruel and unusual punishment. This isn't punishment, this is interrogation.
Yeah.
And see, I would have thought, well, a fortiori, if the Constitution forbids punishing cruelly even people who have been duly convicted of a crime, it would follow automatically that you can't do it to people who haven't been convicted of a crime. But Scalia's line was, well, you've got to go by the letter of the law. You know, the letter of the thing is no cruel and unusual punishment. This isn't punishment, so it's not covered by the 8th Amendment.
Yeah.
Who's right, me or Scalia?
Oh, you're right. But I'll have to go back and look at that. Because I was thinking as you were talking that, it's, I can't think of offhand, maybe Frank would know, if there's any case law involving torture, right? And as it's described as it's forbidden by the Eighth Amendment. And so he's just taken a hard line, right? Biting the bullet. It's not mentioned, so it's not covered. And I think I would tell a different story, a very different story.
Well, in fairness to Scalia, he was specifically asked about the Constitution. There are other kinds of laws against torture, but he was asked specifically about the Constitution.
Yeah. That's a great story.
Are there any other questions or comments from anyone? If not, I want to just thank all of you for coming. And Sam, I want to thank you for your presentation.
Thank you.
And look forward to further philosophy events. We'll have at least one more this semester. Thank you, everyone. Take care.
Thanks.
Thanks for coming and questions.
Well, good job, Sam.
Thanks, Frank.
I think one thing I like, just I guess as people are heading out, but just about the first part about the chain novel versus the patch. Why I like the patch better is because I think it's actually a better idea of the judicial role than even Dworkin has, because a chain novelist primarily works backwards towards integrity, but a patch identifies the problems and kind of tries to anticipate future problems as well. So I think that's why I kind of like the idea of a patch, whether it's a computer patch or whether it's a patch for clothing, that you don't just try to solve the initial problem. If you see that's, I don't